Let's talk about the charges that he's looking at here today. Pull them up. Several charges. I mean, you guys, multiple charges with just this one piece, just on the Erika piece. But there's two different cases in this particular trial. And on one of the cases, he's got count one is to intimidate a victim or threaten force. Count two is intimidate a witness or person charged felony. I don't know how those two are differences, but I guess it's a victim and a witness is two different things. And count three, bail jumping. Now, the reason they've got him on these interrogating a victim or intimidating a victim and a witness is because they had all his calls because the dummy didn't do what he was supposed to do there. And he's an idiot. Let's just face it. We all know he's an idiot. Let's see. His other charges are, I got to pull that up in a different link. I think it's 20. The other one's got more charges to it. So count one is resisting or obstructing an officer. Count two is bail jumping. Count three is second degree recklessly endangering the safety in regards to domestic abuse assessments. Count four is disorderly conduct under domestic abuse assessments. And count five is battery under, it just says modifier domestic abuse assessments. So we've got that going. And the jury's trial is set for Monday. I did want to say that. Jury trial is set for Monday at 8:30. All that means, guys, is that they're going to start the jury selection. So I did set up a stream for Monday, and then I thought about it. I'm like, I don't really think I mean, they're not going to show the portion where they're selecting the jury just because they don't want the jury to be shown. I'm sure they'll have news reports on it. So I may change that stream. I'm definitely going to stay on top of what's going on during the jury selection. And if they have any reports or news reports or anything, what I'll do is I'll just, maybe we'll do like an evening stream where I'll tell you guys what's going on. But the day that they start the case, which I'm thinking if it's a jury trial, they'll need at least 2 days for, how long do you guys think they'll take to do the jury selection? I'm thinking minimum 2 days. Possibly longer, because who doesn't know who this guy is? So, but even if somebody knows who he is, they may not know about this case. They only know about the Waukesha case. Still. You think JPC says 1 day for jury selection? Okay, so maybe it starts on Tuesday. Anyway, you guys, I'll make sure the live stream's up on my channel. We're not going to miss a minute of this. Trust me. And wait. Okay. All right. Thank you. Oh, he looks horrible. Look at his hair. You think it's real or fake? Dollar store hair. Okay, I'm not going to talk. I promise.
Hi.
He is such a thug. All right, I'm going to shut up now. Let me take this off the screen. They have us muted. I don't have it muted, just an FYI. Yep, already running his mouth. Sucking up to the judge like, don't, like they best friends, like we cool and like we cool.
State of Wisconsin versus Darrell Brooks, 21 CF 4596, 21 CF 502. Appearances.
Matthew Tarbinson and Shelley Grosso appear for the state. Good afternoon, Your Honor.
Attorney Russell Jones on behalf of Mr. Brooks. Mr. Brooks appears in person. I appear via Zoom. Good afternoon, Judge.
All right, good afternoon, everybody. When Mr. Brooks first got here, my deputies alerted us to the fact that he wanted to speak with Mr. Jones. Given the fact that Mr. Jones is via Zoom and Mr. Brooks is here in person, the way we accommodated that was everyone left the courtroom, including the spectators in the gallery, the person who is here filming for the media, and obviously all the parties and my staff, except for the deputies. For security reasons, of course, they had to stay with Mr. Brooks. So I allowed them to have a conversation. I wasn't paying attention to how much time it was. It might have been, I don't know, 15, 20 minutes. I allowed Mr. Brooks to have that conversation with Mr. Jones. And then after Mr. Jones alerted the lawyers, I think, and my deputies alerted us, we all came back in. Is that correct, Mr. Jones?
Yes, Your Honor. Thank you.
You're welcome. All right, so we are here for, it was supposed to be a motion hearing and a final pre-trial on these matters. They are set for trial on Monday, May 6th, so that's just a couple days from now. At our last date on January 18th, the state indicated they thought they would be filing an amended information and an other acts motion. The defense also thought they may have been filing some motions, so we set this for about 90 minutes. I set deadlines for that all motions were to be filed by March 22nd and April 19th for the responses. I will note that nothing has been filed from either side as far as any substantive motions. Motions in limine were filed, I just believe, by the defense, and they appeared to be standard. So there is nothing to proceed on as far as any substantive motions. Do we remain in a trial posture, Mr. Jones?
We do, Judge. And with respect to the motion filings, we were anticipating potentially the state filing, and it would have been a response to the other acts. Presumably, they're not seeking that since they didn't file that. So that's why we had nothing else to file other than our standard motions.
Okay. And nothing from the state?
Correct. I anticipate filing another acts motion. I thought about it. The prejudice hurdle would be extraordinarily high in this particular case. And when I gave it more thought, the state didn't anticipate using that other acts because of the prejudicial nature of those other acts, unless there was a defense that triggered the high amount of relevancy to those other acts. And I think that would just as likely happen if the door is potentially opened by one of those defenses being argued in this particular trial. And so rather than file the motion, if the defense becomes that this is an accident or some sort, then I may raise the issue at that point. So, but I did not file another acts motion. That's correct.
Okay. All right. So we'll deal with those issues if they arise during trial. Maybe they won't. So obviously, we have some special issues associated with this case. Jury selection is going to be our biggest hurdle. What I have thought, just on my own, and I don't know if the parties have thought about this, I don't know if anybody would think that a court trial would be a preferable way to go to avoid any of those potential issues that would arise with having a jury and trying to seat a jury with a case that has not, this case is not notorious, but certainly Mr. Brooks's other case is notorious. And we certainly will do our best to seat a fair and impartial jury. But that's just off the top of my head. I think that might be the way, but of course, Mr. Brooks, that is ultimately his decision on whether it would be a court trial or a jury trial. So I just throw that out there. Nobody's requested that at this point. There has been a request for a jury trial, so we will plan on that, but it is just some food for thought, that it may be a way to allow for evidence to be presented without the potential tangential issues that would arise with a jury. So that's just something to think about. In addition to that, if I'm going to go with on the assumption at this point that we are having a jury trial, I have not prepared any written information. I will prepare that over the weekend and give it to the parties, and we can certainly talk about it. But I think we have to address it. no one is going to pretend that we're going to introduce Mr. Brooks and no one's going to know who he is. So obviously it's not going to be, one of the standard questions I asked during voir dire is, has anyone heard anything about this case or about this defendant or had any opinion as to anything? That may foreclose us from seating any of the people that we bring in for voir dire right off the bat, because it was a big deal. The Waukesha case was a big deal. So I will prepare something. Do the parties have thoughts? Or do you want to prepare something as well, and we can kind of put something together as far as a preliminary statement to the jurors? I mean, obviously advising them that this needs to be, you will only judge this case on this evidence, and, asking those questions if they can be fair and impartial and put out of their minds anything that they may know about Mr. Brooks. Each side can submit something if they would like. I'm kicking myself that I didn't think to tell everybody to do this ahead of today's date, so we could have worked it out this afternoon rather than doing it on Monday, but that was my error. I probably should have thought of that, and I did not. So if the parties want to do that, they can do that. I will have some language that I work up as well to address that. Other than that, I just talked with a sergeant from the sheriff's department. In the past, Mr. Brooks has been transported directly here and not really held in the jail, even as a waiting position, until he's brought directly to court. And then generally he's whisked away. I don't know what their plan is. I've got some concerns that if we're going to be in trial, I don't know what the situation would be in the jail, but I have alerted a sergeant in the sheriff's department to my concerns to make sure that Mr. Brooks is going to be here every morning for trial, that we're not going to end up with him being housed somewhere else. But I don't know that's not something that I get involved in generally. I did just want to put it on someone's radar to make sure that we have no delays when it comes to that. Is there anything that, I think your motions in limine were pretty standard, Mr. Jones. So you've both tried many cases in front of me. Everybody knows generally how I run things and how things work. So I think they're standard motions in limine, so they were along with the rules of how I do things. Does the state have anything they want to specifically address on the record this afternoon?
Your Honor, the only thing that I want to address is I do anticipate filing an amended information. I have for a long time been very clear that if this proceeded to trial, that I would file charges of intimidation based on the calls that were made on particular days. And so I anticipate having a total of 6 charges for intimidation of a victim in the amended information. I will get that filed as soon as possible, but I have explained that both to Attorney Jones. I've explained that to previous counsel numerous times in communications on this case. I don't think that's a surprise to anybody. I think on the charge in the underlying domestic violence case, we are going to be proceeding on amended charge of first-degree recklessly endangering safety rather than second-degree recklessly endangering safety. So we will have those charges amended. And if the court wishes, I can prepare the jury instructions over the weekend, if that helps with regards to the charges.
Okay.
And then my only other question is, would the court prefer having information with both cases joined in a single information, or having 2 informations with 2 cases? I can prepare it either way.
That is a CCAP protect issue that is above my pay grade.
Okay.
I think they probably need to be filed in each case. I'm looking at the back of my clerk's head, and she's indicating, yes, that would be better. So separate for the separate cases. Mr. Jones, do you want to be heard as to what Mr. Torbensen's statements or your own issues?
Yeah, let me respond to Mr. Torbensen first, then I have a few things I'd like to address. Mr. Torbensen indicated if it does not resolve with a plea, he would file an amended information and bring all the charges he thinks that he can prove. And that's not news to me, and it's not news to prior counsel. I have requested for Mr. Torbensen, I know I have it in writing somewhere, but I've made a request of him to put his offer in writing because Mr. Brooks wants it in writing in an email, so you could just send me one today with that discussion. Mr. Brooks had some issues with potentially discovery at Boscobel. I'm going to provide him written or all paper discovery that I physically can get my hands on and give it to them also Monday, even though we sent it to them back in March. And I'm not saying Mr. Brooks is not. I'm sure the institution may have lost it, but we can deal with that. I have it all. I'm prepared. The one request, I only have two requests. Number one, I think given the nature of this and the panel and the background, it would make sense if we started maybe at 9 o'clock. I have two quick appearances at 8:15 and 8:30 that I'd like to clear off. If we come in at 9, obviously I think if the three of us get together and decide how to deal with a joint statement, and I would prefer it to be issued by the court rather than the state or me, I think we could accomplish that in probably about a half an hour's time. The other thing I'm going to make this request, and I don't know how much the court has the authority to do this, other than that you can make a request to the jail, but your request would probably be received better than mine, even though I've made inquiries. I know, or at least I've learned now, Mr. Brooks might be moving back and forth to the institution. I understand we can't control that. If at the end of every day of trial, I can have a deputy keep him in the bullpen for some period of time, half an hour, so I can at least meet with him in the bullpen, or if we can break at 4:30, so we can have someone till 5 o'clock, so I can have some time with Mr. Brooks after each day of trial. It may not be needed. I might say, hey, today that we don't need it, but I'd like that little bit of cushion because he's going to be physically removed, and I won't have the opportunity to do that. So maybe we break a little bit earlier than we normally would, so I would have that on days I might need it. Just sort of thinking ahead.
Sure, I think we can accomplish that.
You know, because I want as much communication with Mr. Brooks, obviously, as possible, but I understand I'm bound by the executive, or strike that, the executive branch and their whims.
Judge, it's probably too late for this as well, but I'm just taking in the size of your courtroom physically, and I'm wondering if there's any chance we could switch courtrooms just for jury selection even, because I imagine we're going to have a rather large panel for jury selection.
What I anticipated doing, and I think it probably is too late to plan a switch now. What I would anticipate is I can get 35 in. It's tight, but we can do it. So we can have 35 people in here. And then if we are able to, let's say, seat 8 out of the 35, we will put them back in our jury room and bring a fresh panel of 35 over and do it in that way. I don't have any idea how long this is going to take, given, as I said, the notoriousness of the Waukesha case. So I wouldn't want to guess that one of the bigger courtrooms is going to accommodate it and still doesn't, and have everybody move for those purposes. So I think we just kind of get as many as we can and then start with a new group. So it may take longer than usual. So we may do a couple process of picking a jury in piecemeal fashion. But we should be able to accomplish it in that way. I think if we do run into issues, that may be the best way. So what I'm hearing from everybody is Mr. Torbenson has offered to put together the jury instructions. I appreciate that. And we will all work on what our idea of a statement looks like as far as what to tell the jury about this case, and that it is only this case they are to determine. Not anything else they may know or heard or think or believe they know, or any judgments they've made. And we will question people about that specifically. It's not going to be a general run-of-the-mill, I assume you haven't heard anything about this. You haven't? Yeah. So we will take it from there. So everybody's going to bring that statement, and Mr. Torbenson's going to do the jury instructions. Is there anything more from the defense?
Yeah, and Judge, I have a scheduled meeting with Mr. Brooks tomorrow at 2:30. Apparently that's not going to occur because he won't be at the jail. I'm efforting to get a meeting with him at his institution
I don't know that for sure.
Well, Mr. Brooks is fairly confident of that. Either way, I've got the one set up at the jail. I'm going to try and set up the one at the institution, and hopefully, one of them occurs.
Okay.
And if he can be brought over at 8 a.m. even, I will try and get down there. I mean, I'm just saying, once he's in your bullpen, I think that's, a place that makes it easier for me to get to him. But we'll stay in communication and do what we can, I guess.
Okay. All right. Anything further from the state?
The only thing I want to add is that
Okay, that's not us. That's them. They cut it. They stopped. Why'd y'all stop? All right, let me refresh. I'm going to refresh. Woo! They've got a hang up, I guess. That's not me. It's them. It's all them. Somebody was asking about his oath.
To get to them, but we'll stay in communication and do what we can, I guess.
Okay. All right. Anything further from the state?
the only thing I want to add is that I did tell the court and counsel and chambers, I have a homicide case.
His attorney's gone. It's over. That's it. Don't go nowhere, y'all. Because I got something to show you before you get off. Will he fire his lawyer at the last minute? He's already done that. He's already pulled that. And the whole thing about the jury, we were talking about that earlier. JPC said, oh, one day. Nope. I think jury selection's going to take a bit. There we go.
I can't hear. What? The internet? Oh, okay. So it's just the internet's down.
Oh, they're having internet issues. Okay. It's not just us for once. Your Honor, can I take this time to ask you about subject matter jurisdiction? You haven't addressed it yet. By the way, I'm going to fire him because he didn't show up in person. Let's hope his lawyer does show up in person on Monday. I'm screaming. I think he's going to, but come on, dude. I guess because it was just it was just a pretrial hearing. He thought, well, we'll just do this.
Letting me start again. Let's see if Russ pops up.
So we will be on the hearing. We will be on the trial when it starts. I'm going to try to stay up to date on what the jury thing is doing.
The record isn't clear. We lost Mr. Jones via Zoom.
It says he's in the waiting room.
Oh, he's back. Okay.
Well, we're still connecting.
They haven't shown Erika, Darlene, so I'm sure she may not have to be there today. He's just happy to be out of his little cell. Mary Ann says, look at him behaving himself. Oh, girl, it's early. I want to thank you guys for the super chats and the gifting and everything.
I can see you.
Yes.
You're muted. I don't know if you can hear me.
Your mute is on.
Oh, thank you.
You're welcome.
I automatically ended up muted, but Mr. Brooks pointed out to me that I could unmute. So now we can hear you and you can hear us.
We're back.
All right. So
The last thing I heard was Mr. Torbenson saying he has a homicide trial, has an emergency stay, and then he froze.
right.
I think it's unlikely for the stay to be lifted, and this should be the case that can go on Monday.
Okay. All right. All right. Then I think we just stand ready to go on Monday, barring something else happening. Mr. Brooks, I don't know where you're going to be, but I look forward to seeing you on Monday. Mr. Jones said.
It went out again. We will see you on Monday, you little tick on the wall. You little twerp. I didn't mute it. They froze again. So they're having internet issues at the courthouse. We're not in Waukesha anymore, Toto. The court feed is not as good, nor are the microphones. And, originally, this female judge was not supposed to be, is it Havas or Havas? She was not supposed to be the judge. She was supposed to, she was handling it while it was in pretrial state, and then it was being passed over to a male judge. And now the link or the court docket says she's going to be the one that's overseeing it. Well, let me put this up real quick before I lose everybody. I thought y'all should see this. If you have not seen this before, Brooks brings his own oaths to the jail. She's going to prejudice the jury pool. Kimmy, I don't think so. I don't think she's going to prejudice the judge. I think she brings up a very good point. And here's the thing. If she doesn't talk about it, then his attorney is going to talk about that. And it's going to be one of those things, especially being in the same state. I mean, that was just, I don't know how far away it is from each other, but everybody knows about that trial because he made such an arse out of himself. So there's no way around it. My only worry is that if they can't find a jury and then they do a trial by judge, am I saying that right? Court, y'all know what I'm talking about. You're not here for my legal advice. I know this. I know y'all aren't. But if they don't have a jury and they have to do it the judge has to oversee the trial, then is that going to be something that he can throw up there and do an appeal on? It doesn't matter. He's still in jail and he's going to be in jail till he dies. So I guess it doesn't matter. It says on the screen it's done for the day. Okay. Thank you, Patty. Thank you, Mamacita. So that's where we are. Bench trial. Thank you, Kimmy. Thank you. They could also attempt to change the venue. Wouldn't that have already happened, Leslie? Them trying to change the venue. Wouldn't that have been before in all the pretrial stuff? Because this attorney has been on it for at least a month now. I forgot what date he came on board. I don't know if you guys know, but this is his second attorney. It was in November they came on board. December. No, I apologize. I'm sorry. November of 2021 was when he originally got the other attorneys, and then he ousted them, or they withdrew in August of 2023, and the court appointed Russell J.A. Jones on December 1st of 2023. So he's had some time to work on this. If he was going to do something of the such, seems like that would have already been done. Again, I'm not an attorney. This is what I'm thinking. This is where y'all leave my channel and go over to Southern Law and see what he has to say about this. Let's see. What else? I guess that's it. Yeah, he did break the internet. So, but here's how I'm going to do next week. I'm going to watch this jury thing. If they show anything, if anything's live, they're actually showing something, then we will be live. If they're not, and we're just having to wait for updates, I'll be on top of that, kind of seeing where they are, because a lot of times at the end of the day, you'll look at the tweets and stuff, and they'll say, well, it looks like trial's going to start tomorrow. So we'll be on top of that, which means the stream I have set up for Monday, that time may change. I do have one already set up on my channel for Monday's live stream, and I've got it set for 8:30 in the morning. I'm probably not going to be live on Monday at 8:30 in the morning because I just don't think they're going to be live. So I'll probably, but if they do go live, I'll be there. I'll be up. I'll be in front of my computer, but I just don't see any point of us being here talking about something that's going on that don't really know. You know what I mean? So. I've got the docket pulled up, and I'll keep looking at that. There's just been nothing. I think if anything that was going to throw us off or delay, it would have been brought up here today. They did just updated. It says, final pre-trial proceeded. State informs the court they will be filing an amended complaint, which we heard that. Case remains in jury trial posture. Case is adjourned till 5/6/24 at 8:30 in the morning. So for jury trial. So there you go. I don't think we can delay anymore. I don't think they could delay anymore. So until then, I will touch base with you guys on Monday and we'll see what's going on. And if they're live, we'll be live. So one last time, let me put it in the, let's see if it'll let me do it. This is the link to if some people were saying they couldn't find the link to my patrol. Oh, thank you so much for another super chat. YouTubeaholic. I really hope that he doesn't win a retrial. Yeah, I don't think he's going to. I don't think it's going to happen. I just can't see it. So I'll put the link in for my new channel if anybody's still interested. I just shot it into the chat. And I also, before we get off, I wanted to thank you, Mark Leach, for gifting 5 memberships. You're amazing. You're always there. You must have won another slot machine. Did you get another jackpot, Mark? Janice, thank you so much, honey, for your $9.99 super chat. We love having you here. Linda Cordova, thank you for joining. Auditing Mississippi, thank you for joining. Barbara Seals, Miss Barbara down at the Blue Bayou, Louisiana. She's gifted another 5 memberships. And then, of course, I followed up with some gifting as well. Anytime somebody gifts, I like to try to gift too. So there you go. Let's see. Oh, almost forgot. Carissa Caswell. Welcome to the Hee Hee and the Kiki Club, my dear. You are now an official Brooksaholics Anonymous member. And our next meeting will be Monday at some point. I don't know. I'll be on the lookout. Y'all stay tuned. Make sure you subscribe and come back to my channel and look for notifications in case you don't get one. A lot of people tell me I don't get the notification. I don't know what to tell you about that. I think there's no way for YouTube to notify you of all the channels that you're subscribed to. And I guess that's just a problem that we all have. I too don't get notifications on some of my favorite channels. So just come back to my channel and look out for it. So until then, you all have a blessed weekend. Stay safe. And I will talk to you very soon. Bye, everyone.